on this morning's docket. That is case number 107158, State of Kansas v. Holt.
Good morning. May it please the court. Meryl Carver-Allman, Capital Appellate Defender, on behalf of Mr. Holt. And Chief Justice, if I could please have 3 minutes for rebuttal.
3 minutes is granted.
Thank you. Unless the court would prefer otherwise, my intention today is to talk about the misconduct issue, and then if we have time, touch on the hard 50 sufficiency issue. Excuse me. So to dig straight in on the misconduct issue, we're arguing that 3 separate statements were misconduct in this case, 2 as appeals to sympathy, and the 3rd because it misstated the burden of proof. The first statement is this one, I called it in my notes in shorthand, the fatherless children statement, where the prosecutor in opening statements got up and actually talks about 2 things that are in the facts and we don't really have a problem with. It's this last kind of clause of the sentence that we're really arguing about, I think. And she says, "And you'll learn that the 8-year-old son of Mitch Bose was in the neighboring next-door bedroom at the time the defendant killed his father." That's, I think, fair comment on the case. That Wendy has given birth to her new son, also, I think, fair comment. The part we have a problem with is the appeal to sympathy so now there's a 9-year-old boy and a newborn boy with no dad. That's clearly, I think, an appeal to sympathy, these poor fatherless children that the defendant left orphaned. Also, it plays on parental sympathies, which this court has said is not okay in cases like Martinez and in Tosh. So I think, I don't know, I don't think that there's a lot of question that that was an impermissible appeal to sympathy. Going on to the second statement, the prosecutor says, "Jury deliberation is a privilege that you'll have to right or wrong. You and only you can right the wrong that the defendant has committed in taking a young man's life." This, we think, is misconduct because it was an attempt to inflame the passions of the jury and divert them from their duty to decide the case. And actually, I was the defense attorney in Adams, and when I read this case, it's almost identical to what the prosecutor said in Adams, and this court said was misconduct. So again, I think that that's clear based on that, based on the other cases that say that it's not proper to imply specifically an appeal to justice for a specific victim, as this case does. Again, I think that's clearly misconduct. The third statement is this misstatement of the burden of proof, and I'm not going to read the whole thing because it's rather long. This statement actually drew an objection from the defense. The objection was overruled, and the statement was basically repeated. So to the extent that the state is arguing that jury instructions are kind of a cure-all for that, you kind of have the judge specifically endorsing the statement by overruling the objection. Also, I don't think that jury instructions are the cure-all that the state alleges they are. I think even in Simmons and Henry, they say that it's something to be considered when we're weighing all of this out. But just because the burden of proof jury instruction is correct doesn't automatically kind of wave away any misconduct that the prosecutor makes, any statements that are misconduct that the prosecutor makes in closing argument. To go on to the error analysis, I think I was kind of listening into the case argued earlier. This is 3 statements in the course of a long trial, and I understand that, but gosh, I've said it before, and I'll say it again because I think it's true. Prosecutors should know better than to make these mistakes at this point. This is very old case law. This is very well-established case law. At a certain point, when mistakes like this keep getting made, the recency of Adams, that was a 2011 case. We said, this is not okay. At a certain point, we have to start kind of assuming some ill will here. I just don't know how you can come to any other conclusion. Also in this case, we have a lack of overwhelming evidence. I don't think this court can conclude beyond a reasonable doubt that the error had little likelihood of having changed the result of the trial, as the court must to uphold this conviction. Wendy, the girlfriend, in this case ex-girlfriend, knew the defendant well. She dated him for years, and she couldn't identify him that night. And she, in fact, thought that the person that she saw was the victim's drug dealer, who that was basically the theory of defense in the case, was that the drug dealer had come over and killed Mr. Vos in retaliation for being reported to the authorities and losing his job.
With the shotgun that the defendant purchased.
There's certainly circumstantial evidence in this case. No question about that. But I think the beyond a reasonable doubt standard is very high. The Chapman test is a very high burden for good reason. And given the fact that Wendy could not identify him, I think that dictates reversal here.
Any other factors supporting your position besides that failure to identify him?
The failure to identify him, and then also the fact that her immediate first reaction was that she thought it was the neighbor, the drug dealer. Also, the neighbor drug dealer, was the only other person that saw Mr. Holt. I mean, he was the one who saw him there, him and his friend, that night driving around. So, I mean, it does all kind of tie in, I think, in that way.
I misunderstood that when I read the facts. So the gentleman who was on his porch and went in to make the sandwich, the same person that she thought she saw in silhouette.
Exactly.
I thought it was two different neighbors. Okay, thanks.
If there are more questions on that, I'd be happy to answer them. Otherwise, I'd like to touch briefly on the sufficiency of the hard 50. As I said in my 609 letter, we've got a little bit new standard of proof after Soto. We're to beyond a reasonable doubt standard now. I think there are 4 arguments as to the insufficiency of evidence as to the aggravating factor in this case. The aggravating factor was that Mr. Holt purposely or knowingly created a risk of death to Miss Henderson, to Wendy. First of all, as was argued below, if this is sufficient, then every time someone walks into the room with the gun and shoots someone where someone else is present in the room.
Wait a minute. But the facts are here is that she's lying in bed next to the deceased. Isn't that right? I mean, the gunshot takes place and she's a foot away from where the bullets are penetrating the victim. Am I wrong? It's not just walking into a room and someone's over here and someone's over here. Very close proximity. And why doesn't that put that person at risk of bodily harm? I don't understand why the facts here don't support the finding.
The facts were that he had gotten up out of bed before he was shot, first of all. I understand your argument that they were still close together. I also think, and this is 2, 3, and 4, you have to look at the fact that Mr. Holt purposely worked, assuming he is the shooter in this case, which we're certainly not conceding, they didn't concede that below. Assuming that is true for the sake of argument, he told her not to be there. He said, "Are you going to be there?" She said no. So he was purposely trying to keep her away that night, if that's the case. And there's also not evidence that he knew she was there. Even the district court said, in the sentencing hearing on page 70, the district court said there was evidence that would lead a rational fact finder to believe that the defendant thought Mr. Vos was alone. So the district court that heard all of the evidence thought that, for what that's worth.
There was also testimony that she called out.
There was.
Yeah.
There was. And fourth, I mean, this is sort of a grisly thing to say, but again, assuming my client was the shooter, he was a Marine who'd served in Iraq, shooting at point blank range. Frankly, I think if he had wanted...
With a shotgun.
With a shotgun. If he had wanted Miss Henderson dead, we'd be here on another murder. Frankly, so I think the fact
But that's not what this particular element requires. It's putting someone at risk, isn't it? It's putting some other individual at risk.
But I guess what I'm saying is, if I went in that room and started shooting, I'm a terrible shot, I might be putting someone at risk. But when you assume that he has some shooting skills and targeting skills and the range he was shooting at, again, that a better marksman may not be subjecting someone standing nearby to the same risk. If there are any other questions, I'd be happy to answer them. Otherwise, that concludes what I have.
Any further questions? Thank you, counsel.
Thank you.
Morning, Your Honors. May I please support Jackie Spradling, Chief Deputy District Attorney in Shawnee County, arguing on behalf of the appellee. If I could please address the arguments in reverse as those were presented to you. First of all, the sufficiency of the evidence of the aggravating factor of creating a risk of death to more than one person. I would point out that if you're a Marine or a former Marine, and for that matter, maybe a sniper or a marksman, using a shotgun, however, does project more than a single bullet. It casts a gathering of pellets. And so using the weapon of choice here, using the weapon, does put people who are in close proximity to the victim at a risk of death or injury, as Wendy was exposed to when she was in the bed lying next to Mr. Vose. I also
How far
wanted to...
apart were they? When he gets out of bed to turn on the light, can you give us sort of the layout and the dimensions?
Yes, Your Honor, and for the court's information, I was the trial lawyer below, and the evidence was that Mr. Vose reached for the light switch. There was no evidence that he had gotten out of bed. And looking at the pictures of the murder scene, that is consistent with him being able to do that. I can't tell this court that he did not get out of bed, but I can tell the court that the evidence from Wendy was that as Mitch reached for the light switch, and as I tried the case, I never viewed it as Mitch having gotten out of the bed. And maybe I've been wrong all along.
Where was his body?
His body was down between the wall and the bed, and he took the sheets with him, or the covers with him, which would be consistent with him still being under the covers when he fell. And so in terms of your question, Justice, it was a queen-size bed, and so queen-size beds are ones that fit two adults comfortably, but there's not a lot of extra room in there. So if the two are lying next to one another, even with Mitch reaching for the light switch, that's still close proximity. Let's say for argument that I'm wrong and that I tried it with the wrong assumption and that Mitch had actually gotten out of bed. By looking at the photographs of where Mitch was killed, you can see that the side of his bed where he had been laying was directly close to the light switch. And so even if completely out of bed, he's still only a matter of 2.5 or 3 feet away from the side of the bed. I still would believe that that's creating a risk of death to Wendy. And as has been pointed out, the defendant knew that Wendy was in the bed because she asked who's there, called out in other words, and was told or heard in response the shh. And nobody knows whether that was a shh, be quiet, or the beginning of a cuss word. But there was a response, a verbal response from the defendant when Wendy called out. And going to the prosecutorial misconduct allegations, as noted, there are 3 claims of misconduct. Beginning with the statement in opening, the defendant believes that when I said, now there is a 9-year-old boy and a newborn boy with no dad, that was appealing to the appealing to the emotions of the jury and prejudicing the defendant. I would point out that if you read the transcript of the state's opening, there are 18 full pages of opening statement, consisted of 458 lines. And of the 458 lines, there is 1.5 line that the defendant complains of. What this court will see when you look through the transcript is that the state went piece by piece through not only the evidence that the jury would be presented with, but also the jury instructions. And for a 1.5 line segment, not that you can compare a weight of what was said, but I do think it's significant if you...
So if you commit just a little bit of misconduct, that's okay?
No, I knew you were going to go there when I started that argument, so I'm not sure how persuasive I'm being, but I'm not suggesting any attorney, prosecutor certainly, commit any misconduct. But what I am saying is that it's viewed more reasonably as not having been misconduct if there is a reflection of the evidence. And I am arguing, I hope persuasively, but certainly through my heart, that this was a opening statement that dealt only with the facts that was going to be presented. And I will accept your decision if you tell me I'm wrong, but I don't see that as misconduct.
And why is it relevant that there were 2 boys left without a father?
Let me answer that and then give you an analogy if I could, please. It's relevant because there was one of those boys who at the time was 8, was in the neighboring room at the time Mr. Vos was killed. And so it would be wrong, in other words, for me to have said, the 8-year-old boy is now 9, he's in the 2nd grade, wouldn't be the 2nd grade, he'd be in the 4th grade, and talk about victim impact. But what I argue to you, Your Honor, is that there is no victim impact argument. The 9-year-old boy, Mitch Jr., was not put on as a witness. He did not testify about hearing the shot or being woken up by law enforcement officers after his father had been shot. And I believe that the lack of victim impact evidence is also a lack of wrongdoing. Not entirely, but you can look at that and determine that there was no error.
So why was it mentioned?
I believe, Your Honor, that I was trying to give the jurors exact details of everything that they could expect from me. And I did not see that the mention of a 9-year-old boy and a newborn as wrong. It was as relevant, in my view, as the fact that Wendy was next to Mitch when Mitch was shot. There are people that are
Well,
involved.
that went to prove the crime, did it not?
Yes, sir. Well, the aggravated circumstances, yes, sir.
Explain to me why it's more probable than not that this defendant committed this crime because the victim had 2 sons rather than 1 son or 7 sons.
It's not.
And why is it more probable than not that he committed the crimes because there were any sons?
It's not. But it was going to be part of the state's evidence that the young boy was in the neighboring bedroom and that Wendy was pregnant at the time and that she had since given birth. And the record will bear out that that evidence was presented. I don't believe that there's a challenge that that evidence was wrongly presented. My view of the brief is only that the challenge is that I commented that those things took place. And so...
And it was also painfully obvious. I mean, it's not like you were saying something that the jury didn't know based on your evidence.
That's true. And I hope that it is important, at least to this court, as it was to me, for the decision not to put on the little boy who was in the other bedroom. That, I believe, would have been wrong and obviously did not do that.
Putting him on generally wouldn't have been wrong. He was potentially a witness, right? He could talk about the investigation. There might have been some relevant testimony he could have provided that had nothing to do with victim impact, right?
Yes, Your Honor, that's true. I could have put him on for testimony about being woken up by law enforcement officers and how the police officers tried to shield him when they took him necessarily past his father, and chose not to do that because I didn't want to get yelled at later.
And you were trying to be conservative in your approach.
Yes.
That's your point, and that should be evidence of lack of ill will or gross and flagrant if we find error in the state.
Yes, Your Honor.
Okay.
I agree.
But I understood you were saying that made it not error. That you weren't arguing harmless, you were arguing that because it was a small part and because you were going to present evidence about the boys, that was not error.
As I
Am I
stand...
misunderstanding what you were arguing?
No, Your Honor. As I stand here today, I do not believe it was error.
Yeah.
But I'll also take it from you if you say that I'm wrong. It wouldn't be the first time. I'll certainly defer to your judgment. I don't believe that it was error. If it was error and this court disagrees with me, then it certainly was harmless.
You were the trial counsel, so I'm going to ask you, I'm going to jump you ahead on the third issue because I've got to admit I'm a little unclear what you're saying here.
The burden of proof one?
Yeah, you say when you get to, what you get to do is to know that this is a guy right in the area with the tools he needs, which is the purple crayon. He draws something that favors to him, which is the sunshine, which I don't understand where we're going there. And in this case, the favors to the defendant is Henderson, and he, the little boy, can say I didn't do it all day long, but your responsibility is to decide the difference between possible and probable.
Yes.
Can you explain to me what the point you're making?
I certainly can. And that entire argument was based on whether the defendant's denial, repeated denial of having committed the murder was a probable denial. Not my burden of proof, not my responsibility to prove that it was him beyond a reasonable doubt, but how believable is the defendant's denial. And a review of the transcript will show that I believe it was rebuttal closing, certainly in closing, there were at least 10, maybe 20 times where I said, I didn't do it, which was the defendant's declaration. And then after I said, I didn't do it, I pointed out the evidence that landed, that withdrew or negated the credibility of the defendant's denial. So I was inarticulate, but I can tell you that that's what I was arguing.
And, okay, I'm still not understanding.
Okay.
The possible and probable were being applied to the defendant's denial.
Yes, Your Honor.
And the state has the burden of proof beyond a reasonable doubt. So how does possible and probable with regard to the denial fit within your burden of proof?
Because the defendant's denial is balanced against my burden of proof of beyond a reasonable doubt. My responsibility in showing things such as the shotgun, and that two people saw the defendant in the car right outside the victim's home. My responsibility is proving that the defendant committed the murder beyond a reasonable doubt. And when I'm arguing those facts had been proven, I did not talk about probability or reasonableness. I spoke about probable or possible only when I spoke about the defendant's denial of having committed the crime. And my purpose, my intent was to show that his denial was not credible. And it wasn't credible because even though he said, I didn't do it many times, each time I said I didn't do it, I included right after that facts. Yes, sir?
I'm looking here, maybe it's looks like volume 14, page 526. You're saying to the jury, your only concern in this case is determining if the defendant is guilty or not guilty. And then you say, I want to give you an example. And then you go into the purple crayon example. And we're talking now about the jury's responsibility of finding guilty or not guilty. And then you end that example by saying your responsibility is to decide the difference between possible and probable. How did the jury know that you weren't talking about that in the context of their finding of guilty or not guilty? I don't understand how they were supposed to apply that to a credibility assessment when you're using that for an example of how they arrive at their responsibility to find guilt or not guilt.
I understand your question. I have three answers for you. First, I began in voir dire telling the jurors, or the veneer at that point, that the state's responsibility is to prove the defendant guilty beyond a reasonable doubt. And that beyond a reasonable doubt is not something that could be defined, but rather it was what each one of them believed individually, whether the state had proven it. So first off, in voir dire, I used the beyond a reasonable doubt as my burden. Second of all, Mr. Evans was Mr. Holt's attorney, and during his closing, which preceded my rebuttal, Ron said, we talked some a few days ago when we were selecting you folks about the burden of proof. In a criminal case, it's beyond a reasonable doubt. That burden never shifts. The judge just read you that instruction, and the burden never shifts to Will. He's talking about William Holt. It's always on the state to prove Will did this beyond a reasonable doubt. He makes some other comments, and then Ron concludes with, it needs to be beyond a reasonable doubt. So what I would tell you is that in closing by his lawyer, and beginning with voir dire with me, the jury was clear from two of the three participants that their burden was beyond a reasonable doubt. And finally, Your Honor, the judge indicated in his jury instruction that the state's responsibility was to prove the defendant guilty beyond a reasonable doubt. So you have all of the parties, the state, the defense lawyer, and the judge, telling from the beginning of the trial to the conclusion that I must prove the defendant guilty beyond a reasonable doubt.
What about your point in Bordier where you said, we can't define this for you, it's up to you, and then you tell them your responsibility is to decide the difference between possible and probable?
Yes, Your Honor, and you'll find in the record that I am talking about the possibility of probability of the defendant's denial, not the state's evidence, but the defendant's denial.
I understand that's your argument today. I'm
Yes.
just asking how that fits in. The statement here, you decide the difference between possible and probable, which most people would probably know, versus beyond a reasonable doubt. And in the Bordier, you said, I can't define reasonable doubt for you. You'll have to decide that for yourself. So my question is, in your closing argument here, can it be argued that you are telling the jury what beyond a reasonable doubt means?
I don't believe so, and for two reasons, Your Honor. First, the jury is instructed that arguments of counsel are not the law, and the law as given to them by the district court did set out the proper standard. Had I reflected then as I reflected now, I would not have said probable and possible. I would have said that and then at least tacked on beyond a reasonable doubt. So I did not do it as well as I should have.
Well, in fact, that's one of the things that's troubling to me because, as counsel pointed out, there was a defense counsel objection and there was a conference at the bench. And in that conference at the bench, the judge asked you, what is your rest of your argument going to be? And you told the judge at that point, and this is record volume 14, 527 to 28, that the defendant's denial that he didn't do it was not probable, and there is enough evidence of guilt beyond a reasonable doubt. And when you then resumed your argument, you made the first point, but you never made the second point you told the judge you were going to make. And that might have been enough to have gotten you out of the situation, but you didn't do that, and in fact, didn't do that even after you told the judge you were going to.
Yes, Your Honor, and I did wrong. And I did wrong by not completing the sentiments that I had in my mind, not completing the sentiments that I had just given to the district court. I knew what I was talking about and did not say, as I should have, the final part of beyond a reasonable doubt. And I'll tell you, when I read that, I was elated because I was certain I had said it. And then when I read the transcript, I was disgusted because it wasn't there. And I kicked myself. I should have said that. And I guess I don't remember not saying that, but I definitely rely on the transcript. Here's all I know, Your Honor. I know that when I tried Mr. Holt, as I tried other defendants, I'm not arguing or acting in ill will. That's all I can tell the court. Any more questions for me? Anything I've not addressed?
Ms. Bradling, I just have this is more just a curiosity on my part, not something. Was there evidence about the sequence of investigation, specifically when the police learned that Ms. Henderson thought the silhouette resembled the neighbor, and whether the neighbor ever learned that she had said that to police?
I don't remember Mr. Jones. Josh Jones is the name. I don't remember Mr. Jones. I hope I'm remembering correctly. I don't remember him ever being told that Wendy had indicated that the build resembled Mr. Jones.
Okay, and when was he interviewed by the police? The night of the crime, or
yes, Your Honor. Because as law enforcement were there, there was obviously a large response to this, and Mr. Jones made himself available, as well as Brandy, and I've now forgotten Brandy's last name.
I remember he had a companion on the porch with him.
Yes.
And am I remembering that Mr. Holt, when he was interviewed, confirmed he had had contact with the neighbor or with somebody? Or
Yes.
am I dreaming that?
Yes, Your Honor. Mr. Holt did indicate that he had made contact with Josh Jones and that he had asked for directions. And obviously, Mr. Holt ultimately admitted that he was in the area, that he knew where the victim lived, that he had a shotgun with him. He did deny committing the offense, but he said that he was in the area at the time when he heard the sirens, which the evidence had established was about 15 minutes after the homicide had taken place. And so the evidence in this case was everything but I did it. I was there. I had the motive. She's my world. I was devastated when Wendy left me. I had a shotgun, so everything but and I killed him.
I was confused about the ballistics evidence.
Okay,
The Holt's friend had a spent cartridge,
Greg Hafner, yes, Your Honor.
and that could not be tied to the gun because of the malfunction in the gun. Is that correct? I mean, explain that to me.
No, sure. That particular gun was purchased with the hunting barrel, and it had been changed. The barrel had been changed to a home defense barrel. And in that transformation of the barrels, there was apparently some malfunction which did not allow the shotgun to eject the casing, the shell casing. Now, Mr. Hafner testified that he has a habit. Whenever somebody he's with or he personally shoots a gun for the first time, he collects that shell casing, which he did a week before the murder when Greg and the defendant went and shot this gun for the first time. So the ballistics report then looked at the ejection point on the shell casing that Greg Hafner had taken. And they looked at that because we knew through Hefner's testimony that that shell casing came from the defendant's shotgun. But the reason that was important is because there was no shell casing from the shotgun at the scene. And so there was nothing ballistic-wise from the scene that we can say this is the type of ammunition or the type of gun that was used to take Mitch Bose's life. There was wadding recovered from the victim's body at the autopsy, and wadding, of course, is always in the shotgun shells. But the importance of the ballistic evidence was because we had an extraction mark on Greg Hafner's shell casing that matched the extraction mark of the shell casing that was test fired by the KBI ballistics, Zach Carr, I believe it was, and can show that what Hafner took from their practice rounds did come from the defendant's shotgun. And part of the argument was that that was Winchester shells, and that at the time that the defendant's home was searched, in his parents' home, there was only Remington. And so that was used as an argument that there was some thinking and premeditation, that he had changed the Winchester from Remington. Did I answer your question?
Yes.
Okay.
There's no shell casing recovered from the scene.
That's correct.
So what you basically had was the Ohio man, Mr. Hafner, had a shell casing from the defendant's shotgun.
Yes, sir.
And the defendant was found in the area 15 minutes after the shooting with that shotgun. Is that right?
No, Your Honor. The defendant admitted that he was in the area at the time of the sirens, which was 15 minutes afterwards. But probably, unfortunately for Mr. Holt, is when he returned to Ohio, he gave that shotgun back to Greg Hafner and said, if the cops come asking, let them know that you've had this for a while. And so, were you going to say something?
Well, I was going to say, I'm trying to figure out how the friend's shell casing in Ohio that came from the defendant's shotgun proves anything.
It proves the extraction mark and.
But what do you have to compare that to from the scene of the crime or from the shotgun?
Not from the scene of the crime, Your Honor, but from the shotgun, because the shotgun was test fired by the people at the KBI.
Well, here's my example, and I'll ask Justice Johnson to forgive me. He and I are out shooting pheasant, or trying to shoot in my efforts, and I pick up a shell casing from his shotgun. And then you later confiscate his shotgun and you shoot it and say, hey, the shell casing that Lawton Nuss has is indeed from Justice Johnson's shotgun. Mm-hmm. Help me understand what that proves in this case.
Maybe it's just now sunk in what your question is. It proves that a week before the murder, the defendant was practicing with that gun.
All right.
I'm sorry it took me so long to understand what I was...
And there was nothing recovered from the gun itself?
By nothing...
By in terms of... you said it hadn't ejected. My terminology is probably all wrong.
You're doing fine. There was no ejection.
No ejections, but it was still, when they recovered the gun, there was nothing left in the barrel?
There's no shell casing in the barrel. That's right. It had been manually taken out, but it had not been ejected by mechanism of the shotgun because that mechanism was faulty.
Any further questions? No more hunting questions? All right, thank you, counsel.
Thank you. Just a few quick comments. First of all, record site volume 12, page 168. Mr. Vos was actually out of bed, and that is in Ms. Henderson's testimony. She specifically says those words, out of bed. So for whatever that's worth, that is what the record reflects. Second of all, I want to talk about and hit on something that Justice Johnson picked up. I think maybe looking at this in hindsight and from a legally trained framework, we might be able to understand that Ms. Spradling was talking about credibility, not burden of proof issues. But that's kind of assuming a lot of the jurors, isn't it? I think it is, at any rate. Also, Ms. Spradling said that jurors are instructed that arguments of counsel aren't the law. And that is actually, this has kind of become my pet peeve, that is actually not what the instruction says. The instruction says that arguments of counsel aren't evidence, but they are to assist you in applying the law. Applying being another word for explaining, I think that doesn't really help with the problem in this case. Lastly, as much as I hate to disagree with Justice Beyer, the painfully obvious problem with regard to the first statement about the fatherless boys, I think there's a lot of misconduct that's been reversed that's painfully obvious. The case that comes to mind is Henry, where the prosecutor said, Mother's Day is coming up, think about this victim's mother, think about the fact that she'll never be a mother. That's painfully obvious probably from that case too, and it was still reversible misconduct there, so I would argue that it should be here.
The concern that animates your claim has to do with the inflammation of sympathy or
Exactly.
whatever. It doesn't matter whether it's true or not.
Exactly. And the irrelevance, frankly, I think as several members of the court pointed out. I'd be happy to take any more questions.
Any further questions of counsel? No further presentation?
Thank you.
All right, thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement.